Thank you very much, sir. I want to begin by conveying my deepest gratitude to the members on the other side for their overwhelming support for this bill. And I also want to thank members on my side who spoke in support of the bill as well. Mr. Speaker, the bill has been heralded, rightly so, as groundbreaking and as fundamental to the future of commercial settlement of disputes or the settlement of commercial disputes in our country. It has been recognized as not interfering with our court system, but operating side by side with it. And when there is a need for collaboration, that there is space and facility for that collaboration between the arbitration and the court system. A couple of points, however, were raised, which I want to address, and I'll begin to do so. So, the Honorable Member Chandan spoke about qualifications of the arbitrator. Comrade Ramjatan, the Honorable Member, spoke about conduct. The Honorable Roysdale Ford spoke about two or three issues which I'll deal with in due course. So Mr. Speaker, arbitration has certain inalienable attributes and characteristics that have made it the attractive medium of resolution of disputes that it is. And some of the objections, unfortunately, raised strike at the very heart of those attributes and characteristics. Though the speakers praised the very attributes, they proffer criticisms that refer to the very attributes that they are praising. So all the members spoke about the flexibility of the arbitration, the freedom that the parties have, the regulatory latitude and procedural relaxation that parties to an arbitration enjoy, the ability to choose their arbitrator, that great choice that they don't have in the conventional litigious environment. But it is those very amalgam of attributes and characteristics that allows the parties to choose their own arbitrators and to choose who are qualified to be arbitrators. So from the time you start to interfere with that freedom, then you're going to get yourself in problem. You're going to deviate from the fundamental pillars upon which arbitration is built. It must be assumed that parties who are going to execute a written contract containing an arbitration clause or would engage in conduct or an undertaking that may require settlement by arbitration are going to be persons who are capable of making a decision to choose an arbitrator who is competent to discharge that task. I don't see it any other way. Competent in the sense it doesn't have to be a lawyer, it doesn't have to be a judge. If the dispute is one of an engineering type, then an engineer may be a suitable person. So from the moment you start to list qualifications, you start to hit at the very core of that freedom that arbitration as a concept and as a process confers upon those who desire to use it. And that's why arbitration acts across the globe. If you look at the UNCITRAL model, the gold standard since 1985 that has gone through many, many modifications, there is no list of qualifications for arbitrators. That is part of the flexibility. That is part of the inalienable, commendable attribute of arbitration as a process of settling disputes. The Honorable Ramjatan spoke about the disparity of the affordability of the parties. Well, parties in any dispute may not have equal financial wherewithal. It happens in the conventional legal system. Poor persons may not even be able to afford even approaching the legal system. When they approach the legal system, they can only afford a particular caliber of legal representation, whereas other persons who are better financially endowed would have a different quality of representation. That is life. You can't legislate to change that. But the parties decide consensually who the arbitrators are going to be. At least they have that choice. And the question of costs is also agreed upon in respect of the arbitration even before it commences. Normally, the costs are going to be shared equally, or they can agree that the successful party the losing party, bears the cost of the entire arbitration. That is a flexibility, again, that you have. You don't have that in litigation. Litigation, the principle is the cause follow the event. You lose, you pay. In arbitration environment, you have greater flexibility. The Honorable Mr. Ford spoke about the failure in the Act to provide for a remedy to go to the court to stay arbitration proceedings. Now, that's a valid point, and it does exist in the Singaporean Act. At the level of CARICOM, and so it existed in the Singaporean Act, but it is also absent in many leading jurisdictions in the world that are considered established arbitration centers. Why? Because of the very freedom that I'm speaking about. People are attracted to arbitration, and they became so attracted, being not attracted to the legal process because of all the ills that afflict that system. The length of time, the uncontrollable nature of the system, the subject of appeals, etc. That is why they prefer a system that is separate and extrinsic of that. And they choose arbitration, a mechanism that must not be interfered with by that. Must not be interfered with by that. And that's a conscious decision. Because when they go here, they had 2 centuries of litigation. They don't want that anymore. They don't want the publicity. They don't want the lack of control. They don't want the delay. They don't want that. They don't want that adversarial environment. It would be of little value.
Mr. Speaker,
Mr. Ford.
Mr. Speaker, I stand in order 40A. I didn't want to interrupt the Honorable Attorney General, but I did not say what he's saying. My point was not in relation to staying arbitration proceedings. The point I made was staying the court proceedings in order to permit arbitration proceedings. And I specifically referred to Section 6. But what he said, it was the reverse, attributing that to me.
Very well, but I will address that too.
Go ahead.
I will address that too. So you have that, and I will deal with the natural corollary to that. So you have persons who prefer this because they don't want unnecessary court intervention. My friend seems to be saying that when you go to court, there is nothing stopping the court process to go to arbitration. Every court has a power to regulate its own process. And if a court determines to refer a matter to arbitration, most naturally that court will consider staying the process that is before the court. I can't imagine that the court will continue hearing the matter and then refers a matter to arbitration. That is why that is so unusual and perhaps illogical. I thought that my friend was making the reverse point, because that point makes very little sense. I can't imagine that a court being vested with all the powers that a court has will not be able to stay a matter before the court if the matter goes to arbitration. Obviously, once a case is made out, let's assume that the court doesn't take the matter to arbitration, but the parties agree to. Obviously, a court will stay its hands. Court do not operate in collision course in terms of the determination of a matter. So the point is, I don't accept that as even a valid point. The reverse was a better argument. Mr. Speaker, the honorable member also spoke about public disclosures. Now again, I go back to the fundamental attributes of arbitration. And the honorable member, Geeta Chandan, I want to credit her because she recognized it from the floor about the confidentiality that attend arbitration proceedings. We have an arbitration proceeding going on at the ICSID Arbitration Center in Washington, D.C., the parking meter matter. Now, that's obviously a public case involving a government. Guyana is being sued in that arbitration proceedings. Sued being used very loosely there. But it's not open to the public. It's not a public proceeding in the way that you have public proceeding in the court. And that is the very core and innate characteristic of arbitration proceedings. I look back at the UNCITRAL rules, and there is no public element in the arbitration proceedings. Of course, the parties are free to make the proceedings public, but the bill is not, does not prohibit disclosures, because Clause 64 that the honorable member referred to begins with the statement, arbitral proceedings shall be private and confidential. So that's a general principle of arbitral proceedings being captured. But that's not the end of the section. The section goes on half of the next page, and then deals with situations where it can be made public and disclosures can be made. And among the grounds listed there are if it's something in the public's interest, if it is necessary in the interest of justice, if it is in order to enable some public body or public policy to perform public functions. There are a whole list of exceptions. So a matter of public interest. My friend spoke about, he gave a particular example, any potential arbitration between the government and Exxon. Obviously, that in my view would immediately qualify as a matter of public interest. And it's not by law have to be in camera. There is provisions in the bill. So that is I spoke repeatedly about the flexible nature of the bill. Why is it maintain that sacrosanct principle of confidentiality? It has in it the ability to disseminate and to make its process public if the situation so demands. Mr. Ford also spoke about inactions in the arbitration process, but that's specifically provided for at clause 15 of our bill. He cited section 16 of the Singaporean Act. Section 16 of the Singaporean Act is largely captured at clause 15 of our bill. And it speaks to when there's a failure of the arbitrator to act, or there's a disqualification, or there is some impossibility that render it impossible for the arbitrator to act. You have a whole series of provisions here that would address such an eventuality. So, Mr. Speaker, as I said, this bill went through a very rigorous examination and inspection. It spent almost 6 months with those international law firms, and they interrogated it. The report was a big report that we got back. So that is why I say that this bill is flexible, it's modern, and it is what we need in Guyana. I thank the honorable members for their contribution. And Mr. Speaker, I think that is what I will have to say at this point in time, sir.